My Lord, my issue is dealing with the public participation, and we wish also to adapt.
For the record, you appear for which party, just for the record?
My Lord, my name is Dan Maanzo. I do appear for the 7th petitioner. My Lord, we wish to rely on the submissions of the 7th petitioner, which have been filed, and then go on to Article 10.2. Public participation is one of the values and principles of governance that binds all state organs, state officers, and public officers, my Lord. The Finance Act 2023 did not meet the constitutionally set standard and the threshold of public participation as required under Article 118, whereby Parliament is required to facilitate public participation and involvement of the legislative and offer under the business of Parliament. My Lord, what happens in this particular case? Parliament makes an advertisement to the public, and the people reply by way of personally participating or through memorandums or through affidavits. That happened in this particular matter. There was a little bit of public participation which took place, but unfortunately, when the act was introduced and while it was on the floor, there were other amendments which were introduced, which were not subjected to public participation as it is a practice. The moment you go on third reading and other amendments are introduced in the House, ordinarily they are sent back again for public participation, and the public is recalled. That did not happen in this particular case. We have highlighted that very well in our petition. And the question as to what amounts to adequate public participation was addressed in the case of Commission of the Implementation of the Constitution versus Parliament of Kenya and another 2013 EKL. 2013 EKLR, where it was held that what matters is that at the end of the day, a reasonable opportunity is afforded to members of the public and any entities, parties to know and parties to know about the issues and to have an adequate say. What amounts to a reasonable opportunity will depend in the circumstances of each case. So, my Lord, in this particular case, as I've just said, once new provisions were introduced, again as a practice of Parliament, that did not happen. And these particular new articles, which, my Lord, in our petition, the provisions that were introduced after clause of public participation exercise in our paragraph 7 and 9 of the 7th petitioner. You'll find all of those provisions there. There are quite a number. And they are the ones which touch on some of the key issues, my Lord, in this particular petition. Then, my Lord, the petitioners contend that the National Assembly sneaked many provisions of the law into the approved bill on the floor of the House without subjecting them to public participation, hence violating Articles 10.2, 118, and 201 of the Constitution. My Lord, let me end by saying that when that fails to happen, and we have clearly demonstrated, and there is overwhelming evidence that happened, my Lord, unless those particular provisions are subjected to the people, and they are very key, and they affect the people of Kenya, who have the sovereign authority, then, my Lord, in regard of public participation, this bill fails in those particular provisions which were introduced and were not sent back to the public participation. And, my Lord, public participation, adequate public participation, following the advice of advisory opinion, which you have also cited there, Parliament was proposed to make a law on public participation. There was a bill of 2019, and unfortunately, when Parliament adjourned, collapsed that and has not yet been introduced. So, my Lord, the country is yet to have a law on public participation, but there is sufficient guidelines in the Constitution as to and by the court decision as to what public participation must be. My Lord, for those reasons, this act fails. The Finance Act 2023 fails for lack of proper public participation, and this court, even if it doesn't find the whole act wanting constitutionally, then these particular provisions, my Lord, should be taken back to the House. I thank you, my Lord.
Mr. Maanzo,
yes.
This case of commission and implementation of the Constitution, and this time you just read what the judge is saying. I just wanted to clarify what, in your view, should be reasonable opportunity, or what do you understand by reasonable opportunity?
Reasonable opportunity, my Lord, from what you've been practicing in the House, is an advertisement through the newspapers, receiving of memoranda by the House, and then documents, and people be given an opportunity in a public place, which has been happening in all other acts of Parliament, and especially Finance Act in every year. There's usually a big meeting at KICC, which is well advertised. But what happened in this particular case, and we have put it in our submissions, the moment new provisions were introduced, I believe because of pressure of time, they were not subjected back to the people as it has always been the practice. So a reasonable opportunity was not accorded to the people of Kenya to make their contribution on the new additional provisions which were amended on the floor of the House. But unfortunately, the House did not go back to the people and went on to pass those particular provisions, and we have highlighted them in our submissions.
Thank you.
Much obliged, my lords.